7 major US immigration changes. What changed, mistakes to avoid, and what to do now. Good morning, everyone. Welcome back to my channel and welcome to another edition of our weekly immigration updates. Immigration law and policy are changing very quickly, and these changes are affecting asylum applicants, students, visa applicants, green card applicants, work permit holders, and even people traveling within the United States. Today, we are going beyond simply telling you that a rule changed. For every update, we are going to answer 4 questions. What changed? Who does it affect? What mistakes are people making? And what should you do now? Because one of the biggest problems we are seeing is that people hear one sentence on social media and immediately make decisions about their immigration cases. So please listen carefully. Having a pending immigration case does not automatically mean that you have lawful immigration status. Having an employment authorization document does not necessarily mean you have immigration status. And being allowed to remain in the United States while a case is pending does not necessarily mean that you are protected from every form of immigration enforcement. Let's start with one of the biggest changes affecting asylum applicants. USCIS can now refer some affirmative asylum cases to immigration courts without an interview. What changed? Effective July 28, 2026, the DHS amended its regulations permitting USCIS to refer certain affirmative asylum applications directly to immigration court without first conducting the usual asylum office interview. USCIS still must offer an interview before it actually grants or denies asylum. This is important because historically, many applicants expected that they would have an asylum interview first and would have an opportunity to explain their case to an asylum officer. That assumption is no longer safe. Who can be particularly concerned here? Cases where the written records raises an obvious issue, including the 1-year filing deadline, possible asylum bars, serious deficiency in eligibility, immigration history problems, or other factors that could support referral. The AILA specifically identifies the 1-year deadline and officer's discretion among the factors implicated by the new rule. AILA advises mistake people make. Mistake number 1, I will just submit the I-589 now and explain everything at my interview. That has become much riskier. Mistake number 2, not properly explaining why the asylum application was filed after 1 year. Mistake number 3, leaving major inconsistencies between the I-589 visa applications, border statements, and previous immigration filings. Mistake number 4, assuming referral to immigration court means automatic deportation. It does not. It means the asylum claim proceeds before an immigration judge. What should people do? Your asylum application needs to tell the legal story from the beginning. Review the 1-year deadline, develop the protected grounds and nexus, explain the prosecution, address government protection and internal relocation, disclose immigration and criminal history accurately, and do not assume that USCIS will give you an interview before deciding whether your case belongs in the court. For now, the takeaway is this. Ensure you check the EOIR website to ensure that your case is not there yet. Do not file an incomplete asylum case expecting the interview to fix it. Our next immigration policy update is the Immigration Enforcement and Domestic Air Travel. Can you be questioned or detained while flying from one US state to another? The answer depends heavily on your actual immigration situation. This is an enforcement risk development rather than a new USCIS regulations. Mistakes people make. Mistake number 1, I have a pending asylum application, therefore I have lawful immigration status. Not necessarily. Mistake number 2, I have a work permit, so immigration cannot detain me. An EAD primarily establishes employment authorization. It does not by itself resolve every immigration status or enforcement issue. Mistake number 3, I have advanced parole, therefore I cannot have immigration problems. Advanced parole and lawful immigration status are different concepts. Mistake number 4, traveling without understanding an old removal order, unlawful entry history, or criminal issue. What should people do? If you have complicated immigration history, do not make travel decisions based only on the fact that you have an EAD or pending receipt notice. Know exactly what your legal position is before unnecessary travel. People with prior removal orders, unlawful entries, overstays, criminal history, or other complications should obtain individualized legal advice. And I will emphasize, pending case, lawful status, lawful presence, employment authorization, and permission to travel are not the same thing. Our next issue is the public charge changes. Next is the public charge, and I want to address this very carefully because this is where panic can cause people to make terrible decisions. The DHS July 2026 rule rescinds the 2022 public charge regulations. The new framework becomes effective September 18, 2026 and applies to qualifying applications for admission or adjustments filed on or after that date. The mistakes people make: 1, stopping all public benefits immediately. 2, taking a U.S. citizen child off benefits because the parent is worried about immigration. 3, assuming every immigrant is subject to public charge. They are not. Mistake number 4, assuming every government benefit is treated individually. It isn't that simple. What should people do? First, determine whether public charge even applies to your immigration category. Do not cancel health coverage, food assistance, or benefits for your children because of a TikTok video. For applicants who are subject to the public charge ground, preparation may include reviewing household income, employment, assets, health-related circumstances, and sponsorship documentations. The key takeaway is this: do not give up benefits first and ask legal questions later. Ask whether the rule applies to you first. Our next issue is the international students and the end of duration of status. For decades, many international students have been familiar with those two letters on the I-94DS, duration of status. The government is moving towards fixed admission periods rather than simply allowing qualifying students and exchange visitors to remain for the duration of their program. This is particularly important for F and J non-immigrants. Mistakes people make. Mistake number 1, I'm enrolled in school so I can remain indefinitely. Do not make that assumption under the framework. Mistake number 2, never checking the electronic I-94 after entering the United States. Mistake number 3, thinking the visa expiration date and authorized stay in the United States are necessarily the same thing. They are not. Mistake number 4, waiting until the last minute to deal with an expiration date or program extension. What should students do? Every international student should develop the habit of checking the I-94 after admission. Know your I-94 expiration, your I-120 or DS 2019 program dates, your school reporting obligations, and when an extension or other immigration filings may be necessary. And speak with your DSO or immigration attorney before, not after an immigration deadline. Key takeaway is this: students must begin thinking in terms of immigration deadlines, not simply school enrollment. Our 5th update that immigrants and applicants should be aware of is the $750 expedited B visa appointment pilot. Now, this one is going to attract scammers very quickly. The State Department is testing a program under which eligible B visa applicants at participating posts can pay an additional $750 to obtain an interview within 10 business days, subject to appointment availability. It began in Mexico on July 21st, 2026. Applicants still pay the normal $185 MRV fee. Most importantly, the $750 buys an earlier interview. It does not buy a visa. The mistakes people make are: 1, once I pay $750, they are more likely to approve me. No. Mistake number 2, paying a third party who promises a guaranteed expedited visa. Mistake number 3, thinking the program is automatically available in every country. It isn't. Currently, State Department says it is available only at participating locations and additional locations may be added. Travel.state.gov if you want to know more about it. Mistake number 4, missing the expedited interview after paying. The fee is non-refundable and a missed appointment results in forfeiture. What should people do? Use only the official State Department appointment system. Prepare for the visa interview exactly as seriously as you would without expedited processing. You must still prove your eligibility for the B visa. Here is a bonus update. State Department also changed its instructions in July, so non-immigrant visa applicants generally should schedule interviews in their country of nationality or residence. Applying elsewhere can make qualifications more difficult. Our sixth update is the August Visa Bulletin. Next, the Visa Bulletin. This is one of the areas where people make expensive mistakes because they hear that their category moved and immediately conclude, I can file my green card now. Mistakes people make. Mistake number one, looking only at the visa bulletin and not checking which chart USCIS permits adjustment applicants to use that month. USCIS explains that the visa bulletin contains both final action dates and dates for filing. And USCIS determines which chart adjustment applicants may use in a particular month. Mistake number two, not knowing their priority dates. Mistake number three, confusing dates of filing with final action dates. Mistake number four, assuming a current priority date cures other adjustment problems. It doesn't. A person still has to independently qualify for adjustment of status. What should people do? Know these three things: your immigration category, your priority dates, the USCIS chart authorized for the month. Then determine whether you are otherwise eligible to adjust status. Our key takeaway is this: visa availability does not automatically equal adjustment eligibility. Next is the work permit, new restrictions, fees, and court litigations. This final topic needs special caution because several EAD developments are happening at the same time. There have been statutory and regulatory changes involving asylum fees and employment authorization, along with ongoing court challenges. The April 29 DHS interim final rule codified asylum-related fees and EAD provisions, and DHS issued a correction on July 21st. There has also been litigation affecting implementation of certain HR1 related provisions. Here is the biggest immigration mistake. I want to end today's program with perhaps the biggest mistake immigrants are making right now. People are using immigration terms interchangeably when they do not mean the same thing. Someone will say, I have a work permit, so I have status. I have a pending asylum case, so I am legal. I have advanced parole, so I cannot be detained. I have a priority date that is current, so I can automatically get my green card. I paid for expedited processing, so my visa will be approved. None of those statements is automatically correct. Immigration law is becoming increasingly technical, and these distinctions matter. The lesson from all the updates is simple. Do not rely on assumptions. Know your exact immigration category. Know what documentations you have. Know what the new rule actually says and obtain individualized advice before making a decision. And remember, today's discussion is general educational information. Immigration cases are highly fact-specific, and a rule that creates a problem for one person may not apply at all to another person. So, which of these 6 changes actually surprised you most? Is it the asylum interview rule, the airport enforcement, the public charge, student status, or the 750 visa appointment, the visa bulletin, or which of these? Put your questions in the comments and we will take them one after the other. Thank you very much for watching, and I hope to see you in my next episode of Immigration Updates.